lecture on Irish contract law. We will be discussing the unilateral contracts and acceptance by conduct in common law, the contractual liability of advertisement, and consumer rights in the digital services and products sphere. The Consumer Protection Act governs Section 53, specifically that of digital services. And information provided by a trader becomes integral to the contract, and there must be an expectation provided for in the digital service of conformity with this information, and the consumer has a legitimate expectation from a pragmatic perspective to expect the digital service to match that which it is required to provide. Section 54 governs the requirements of a digital service, and for the purposes of clarity, digital service would be inclusive of applications available on a Play Store or the Apple Store, or any such application that might be useful in a digital provisional service. It must be fit for general purpose, and it must be suitable for the purposes that it is typically used for, considering an app on a phone. For example, a standard issue calculator app available on a telephone mobile device. It must be specifically able to provide the services of a calculator that it would typically be able to be used for. It must be able to add, subtract, divide, multiply, and provide some other basic calculable function. It must be consistent with the trial versions, and therefore the consumer must be able to legitimately expect that it will match in quality and function of the version that the consumer was trialed, if such a trial is on offer. Trial versions are indeed a way for companies to market their wares to a consumer for the purposes of coaxing, inviting a consumer to consider potentially purchasing a product, leasing a product, or indeed buying a product that is more costly and therefore profitable for the company itself. And therefore the trial version must reflect the reality of the full product. Specifically, perhaps for a video streaming service, that the trial version must reflect the consistency available in the premium service so that the consumer can make a full appraisal of whether or not the full product is indeed for them, or perhaps the trial version has been sufficient to either dissuade or dissuade the consumer in venturing further into contract with the digital services provider. It must comply as a digital service with the public statements. No misleading statements are permissible, and any misleading statements that are sanctioned by the company that mislead consumers as to the provision of the digital service are unlawful under Section 54 of the Consumer Protection Act, actionable by the Consumer and Competition Protection Commission and by private prosecution in consumer legislation in Irish law. Section 64 governs modification of digital content and services, specifically using the example of an application on a telephone mobile device such as an Apple Store or Play Store. It is permissible to update an app if it is in the contract, and there must be a valid reason for an update. Such examples would include IT patching or cybersecurity interests for the purposes of maintaining security of information. For example, under legal requirements of the Data Protection Act, there may be incidences when apps demand a update, or for example, for certain telephone devices, routine updates allow for the latest features to be installed. And this is quite clear and reasonably well published and in contemporary discussion concerning digital content or services on such devices. And therefore, this would in and of itself become a valid reason. And if it is permissible in contract, it is therefore sanctionable by the company in the provision of the digital content or service. Again, turning to the option of a telephone app, modifications cannot incur an extra charge on consumer, and therefore, if an initial payment has been made, no further software digital updates can incur a charge on the consumer. Indeed, if a price has been paid for an app or a service or an update initially, there can be no further charges for the purposes of updating. The policy grounds behind this is that a software developer could, in theory, continually update so as to raise increased revenue and delaying certain modifications over a 3 to 4 modification stage period rather than delivering all modifications in one fell swoop so as to maximize income flow or to spread income over a greater period of time. There's a positive duty on providers of digital contents and services under Section 64 to provide clear and comprehensive information on any modifications or updates. And finally, there must be no negative impact on the consumer in the modification of the digital content or service entered into contract. Therefore, if a video streaming site installed as a digital service or indeed online seeks to update an account or contract, there must be no negative impact upon the consumer in the modification or update thereof. In the Carlisle and Carbolic Smoke Ball case, we will now consider contractual liability in advertisements. The claim for a product to prevent flu by the respondent with a reward supplemented in the event of the contraction of a flu was going to be sanctioned by the company in the event of the proper and prescribed use of the product prepared by the respondent. The sincerity of the respondent was articulated in a significant sum, many times greater than the reward deposited in a bank, and publication was freely and publicly available of such same information. The applicant in this case used the product as directed and nonetheless contracted influenza. They claimed they were entitled to the reward, whereas the respondent claimed that there was no legally binding contract and it was merely an advertisement ploy. The advertisement, as held by the courts, was precise and meant to be taken seriously, and this seriously compounded the seriousness of the actions of the respondent in the deposition of money in a bank many times greater than that of the individual reward on offer in the advertisement by the respondent. There was acceptance via performance of the consumer in the procurement of the product itself, the consumption of the product, in the hope that there would be no contracting of influenza following the correct and prescribed use of the product itself, that of a smoke ball. Consideration occurred because there was a benefit in the purchase for the respondent in mere financial terms, and indeed increased advertisement and marketing as a result of the promotion of the reward. Indeed, in these periods, it was likely that such promotion was widely a significant sum of money and therefore of ordinary and contemporary conversation at the then time amongst circles of individuals, as in these days the flu vaccine was not so widely available, therefore the influenza would have been a lot more chronic and potentially fatal, and any such product that was proposing to us so as to prevent flu would indeed become a rather pandemic in nature itself, to pardon the pun, across the market of consumers. And furthermore, consumers might have had less of a general knowledge of science and therefore not be able to rationally nor reasonably draw the conclusion that smoke balls could not logically prevent the contraction of flu. And therefore, the usage as directed could not be the then lingua franca or mentis franca of the people have been reasonably perceived to be able to divine that such use of a smoke ball could not indeed prevent flu. The applicant nonetheless won, therefore directing that advertisements were precise, may be taken seriously, and once reasonably thought to have been of a serious nature, and their sincerity in the advertisement offers will be held to have been made, acceptance via performance of the consumer, and there is indeed consideration in this matter. In the Barrowman and Abt case, this case considers consumer rights under common law, where a ski trip with an undertaking was booked. However, the undertaking itself wound up prior to the trip. The Association of British Travel Agents, of which this wound up company was a member, promised to refund or offer alternative arrangements to customers in the event of financial failure of a member organisation of the ABTA, of which the wound-up company was. ABTA's offer was unambiguous and therefore a strict offer in contractual law. They incurred contractual ability once the acceptance was complete, which was the case, and the booking of the undertaking to go on a ski trip with the undertaking that was wound up prior to the execution of the ski trip. The acceptance, therefore, was via the booking agent, and this was an implicit agreement with the terms and conditions of the notice by the applicants of the notice given by the respondents, and therefore the contract was held to be binding. Compensation was duly rewarded.